On behalf of the Office of Gift Planning and the Shaw Society, let me welcome you here this morning for this program, this estate planning for everyone. And we're thrilled with the crowd that has assembled here today to learn from a real expert in the business of planning for your future. Mike Puzo is an attorney who has 2 degrees from Boston College, both an undergraduate degree and a law degree from BC. He has spent his entire career at the law firm of Hemingway and Barnes, where he is a partner in the Trusts and Estates Department. As part of his role, Mike serves as outside counsel to Boston College, as well as to the Archdiocese of Boston and the New England Province of Jesuits. Mike has received numerous professional accolades and awards, including the distinction of being known as a New England super lawyer. He's also deeply involved in community and civic affairs and currently serves as the town moderator in the town of Hingham. Most importantly, he is a proud and engaged Boston College graduate. Mike has done so much for our university over the years, and we're thrilled that he has agreed to come here and talk to you today about how to prepare for your future. So please join me in welcoming Mike Puzo.
Thank you, Tom. Very kind. Oh, thank you. What I'd like to do today is walk through this outline, which I think will be a useful way for all of us to understand what is often considered to be some sort of arcane topic. And you might think, well, gee, this guy's been doing this for 36 years, so he doesn't think it's arcane, but I do. I guarantee you, at least by the end of the hour or so we'll spend together, that you will see that it's not that arcane. I think sometimes we lawyers try to make it so, because then you have to come to us, and we answer your questions in words and phrases that no mere mortal could understand. But estate planning is really pretty straightforward stuff, particularly for most people. I'll say by way of quick background, the tax situation, which is where people usually start when they're doing what I'm doing. To me, the tax tail should never wag the dog. You should first understand the basics of what a will is, what a trust is, what a healthcare proxy is, what a durable power of attorney is, how to provide for yourself, your spouse, your kids, and also take some solace in the fact that the bar is now set so high for the payment of federal estate taxes that very few Americans ever run into the federal estate tax system. So as I'll explain in more detail in my remarks, until you have more than $5+ million of assets as a single person, you don't bump into the federal estate tax at all. I liken it to a limbo stick. They set the stick now at $5+ million, so most people can walk right under it. If you're married or you think, gee, I should go get married because then I'll get another coupon, then the husband and the wife share together 2 gift tax, estate tax exemptions. So a couple that has, only a couple that has more than $10.5 million is going to have to worry about a federal estate tax. I will spend some time, particularly since we're here in the Commonwealth of Massachusetts, when I get to a tax piece, talking about the Massachusetts estate tax, which is the tax most human beings have to worry about who live in the Commonwealth, because that begins to bite at you in noticeable ways when you have $1 million. And people who say, well, I don't have $1 million, you start to add up what you've got, your TIAA CREF, your life insurance, your group term life insurance, your house, your condo, the cottage at the Cape, and all of a sudden you think, holy smokes, I've got $1.6 million worth of assets. You don't feel as if you do because it's not money sitting in the bank, it's not stocks and bonds that you can kind of marvel at every quarter as it goes up and up into the 16,000 range. But the fact is, most people have more money than they think they have, particularly if they're willing to die to get it. Okay? All right, so first we're just going to focus on one other prefatory comment. If you have a question where you're just lost, like I just am lost, then put your hand up and we'll try to get you back on track. If it's a question that can wait, jot it down. I know that there's a kind of a printout of my remarks with some places where you can put a question, and then I'll take them at the end. But again, I don't want to lose someone, at least unintentionally, okay? So the notion of estate planning. Why do we do it? I tell clients, when you're doing a will, and I'll use that phrase even though sometimes it's not a will per se I'll be talking about, when you're doing a will, it is just what its name implies. It's what you will to have happen with your property when you die. So just imagine, I tell clients all the time, just take out a blank piece of paper, make believe you're just sitting there with it, you know you're going to die, the plane's going down or some awful thing, and you want to write out, you're going into battle, you want to write out who do you want to get what, when. So estate planning is designed to first cause you to gather all the things you own. You make a list, you make an inventory, we send out a questionnaire, and it forces people basically on their own nickel to sit down in the comfort of their home when they can get access to their records or go to HR and get printouts of what your balances are and whether you've got somebody named already on things. And you begin to gather your information, just as if you're going on a trip, we'll call it euphemistically, a trip from which you will not return. And you sit down. So the first thing is you're planning for the disposition of your estate, right? That's why they call it estate planning. So first you have to figure out what you have. Then you have to figure out who owns it. I can't tell you, of course you have to figure out who owns it. I can't tell you how many times we sit and say, oh, actually I don't own that. It's held in a trust. Or I thought it was a tenancy by the entirety. It's actually a tenancy in common. These are differences with major distinctions. So again, on slide 1, estate planning is the process of ensuring A, you know what you own, B, at your death it's going to go to the people whom you designate. It's only going to go to them when you want them to have it. So if you have a special needs child or grandchild, if you want to provide for a second spouse, you're remarried, have children from a first marriage, you want to provide for husband or wife, but ultimately ensure that property will go to the children of your first marriage. At certain times, maybe you have a child who isn't very good with money, and you don't want that person to get a lump of money at 21 or 18 or even 40. So that allows you, this process allows you to do it. That's what bullet 3 means. You get to select the form in which you want the person to receive his or her effectively inheritance from you, and of course you want to minimize tax costs. As I said, the federal government has kind of done that for virtually all Americans by lifting the bar so high that virtually nobody bumps into it. If you do have some extraordinary estate, either for Massachusetts purposes or federally, there are ways to reduce, if not eliminate, the tax. And then, of course, increasingly, particularly with Americans living so long, people have to plan for incapacity. Increasingly in our practice, which is, as John said, I'm focused in the trust and estate area of our practice, we are seeing increasingly people who are living a very long time and do not enjoy the kind of mental capacity or acuity that they had when they were 60 or 70 or 80, now that they're 95 or older. One of my clients has just celebrated her 105th birthday and wants to take a look at her estate plan. True story. And she also knew that she likely wasn't going to have to pay a tax with the new exemption being $5 million. So I corrected her and told her it was more than $5 million now. So incapacity is a big part of estate planning now. Now, one of the things I'm not going to talk about, and I know there's another program that focuses, or actually 2 programs that the Alumni Association and the Shaw Society are sponsoring, one of which is focused on retirement planning, one of which is focused on planning for public benefits effectively, Medicaid planning, mass health, nursing home costs. That is not an area in which I have any expertise. So, okay, suppose you don't do this. You say, gee, I went to a lawyer and he or she said it was going to cost, $1,000 to have an estate plan done. So I'm not going to do that. I don't want to spend that money. I'm going to do something else. So what happens? I think it makes sense to show people their options. If you die without a will, in one sense, the state will provide one for you, we'll say. So I suppose if you would let someone else dress you and feed you and select what you're going to eat every day, then you can just leave it to the Commonwealth of Massachusetts, because they have some laws out there that say if somebody dies with property and no will, we'll do our best to figure out what would a rational person who leaves a spouse or some kids probably want to have happen with his or her property, and they call that intestacy. Here we are at this classical university, and of course, a person dies with a will and a last testament. They die testate. If they die without one, they die intestate. Massachusetts intestacy law will govern the distribution of what lawyers call probate property. And again, going back to our high school or college Latin, probate means to prove, probare, to prove. So when one has a will, one has to go to the probate court to have the will proven as the last will and testament of Jane Smith. And if you don't have a will, then of course you still have to get your probate property moved on. And what's probate property? Probate property essentially, and this is one of these critical distinctions, if you're going to follow up and go get a will and a trust done, you will really start to wow whatever lawyer you go to if you understand the difference between probate property and a non-probate property. Probate property essentially is property you own in your own name. So I am Michael Puzo. If my house in Hingham was titled in my sole name, then I die. Someone says, well, gee, who owns the house now? He's dead. Who can give a deed? Who gets it? You'd have to look at my will. That property would pass under my will and therefore would have to go through probate. Non-probate property. Most people own a lot of non-probate property. And the simple way to remember the distinction is, does it take care of itself? Does it go someplace kind of on its own? Or do I have to go to the court to get title? Because the reason you go to the probate court, and all these things about how to avoid probate, and is probate like a root canal or something? Is it really bad? It's not so bad. But it's certainly something that one would choose to avoid if one made a conscious choice, and you should make a conscious choice, because there's delay, there's expense, and for people who are worried about privacy, the probate property is a public process. So you can go to the probate, if you had some prurient interest, you could go to the probate court and look up the probate of X's estate and see what he or she left. But all you would see is what had to go through the probate court. Sometimes you'll see some celebrity or wealthy person passes away, and there'll be a newspaper article about the person's will, or their probate records show an estate of $7 million. And you think, gee, I would have thought that person was way wealthier than that. That's because you're only seeing part of the picture. You're not seeing all the non-probate property. Simple examples of non-probate property are joint property, so husband and wife, tenants by the entirety, or husband and wife joint tenants. Life insurance. I've got a life insurance contract with SBLI. If I die, Christine, my wife, gets a bunch of money. That doesn't have to go through probate. There's a contract. I've signed up for life insurance, right? Or I've gone down to the HR office and I filled out a bunch of forms if I'm a Boston College employee. I have group term life. I have my IRA. I've got my 401k, my TIAA, CREF. And I say, in the event of my death, I designate beneficiaries. For people who were Shaw Society members, they may have said, upon my death, I want 1/4 of my TIAA CREF balance to go to Boston College for its general purposes. Upon the death of that person, 1/4 of the TIAA CREF balance would, by contract with TIAA CREF, go directly to Boston College. It would not have to go through probate. So one of the things you're doing when you're doing estate planning, whether as a drafter or as a client, is you are making sense of a whole bunch of things that could otherwise be loose ends. And I think without getting judgmental, it's really kind of irresponsible when somebody dies and their children or spouse or grandchildren really are left with a mess. And it's quite avoidable. Estate planning does not have to be real complicated, but it does have to be. So again, we split here between probate and non-probate. If I can leave you with a few things in the course of today's remarks, It will be understanding the difference between probate and non-probate property, understanding some of the basic deductions that are particularly relevant for Massachusetts purposes, where you really have a mass estate tax to try to minimize or avoid, legitimately avoid. So probate, property you own in your own name, it's got to go through probate to get to the next owner. And remember that real estate, if you own a house in, Massachusetts, but you also have a cottage on the Rhode Island shore or a condo in Florida, real estate, not surprisingly, a lot of this is perfectly logical, real estate has to be administered under the laws of the state where it's located. Right? You got to go to the registry of deeds. I mean, if you got a place in Sarasota or something, you have to go deal with it. That's something that you can avoid. A reasonably skillful lawyer can show you how to avoid needing to go through what is called ancillary probate. I handled an estate recently, which was kind of, I'm thinking a polite way to say it, less well planned than it might have been, and. We had to do 4 probates, in 4 different states. It was a big waste of time and money. So you try to avoid that. Non-probate property that passes to a named beneficiary. So again, you don't have to go through the probate system to get it where it's destined to go. Simple examples, life insurance, IRAs, annuities, TIAA, CREF, things like that. Also joint property. So if you have sometimes for convenience, I'll see an older client who might have a joint account where the joint owner is a son or a daughter, because for convenience they want the adult child to be able to go to the bank, maybe to cash checks, to write checks. They trust the child. That's joint. I will say that's another thing to put a star next to. It is often a source of division and discord. Classic. I mean, it happens so often. It's like whatever, the trees lose their leaves and the children fight over the joint account. Why? Imagine you got 3 kids, one of them's local, she's doing all the stuff, she takes mom to the hairdresser, she takes mom to the nursing appointments, the doctor's appointments. There's a joint account with that daughter. It's got $100,000 in it. Mom dies, daughter says, that's a real joint account, it's my $100,000. The other 2 kids say, what do you mean? That was a convenience account. Mom didn't expect you to get all that money. Well, where were you when mom needed to go to the doctor? Where were you? Where were you? If you want to have a real joint account, then make it a real joint account. If you want to have a convenience account where somebody just has banking access, then there are very simple ways. Any bank, officer will know how to do it. You give them basically authority over the account, but you don't title it in their name unless you intend either to let them have the money in a true joint account, or whether you would like your children to fight after your death and think this will be a clever way to start it. Property that's held in a trust is also, again, because title's not in your name, remember? In order to go to the probate, why do you go to the probate court? You go to the probate court to get title out of your name and to the next owner. If property is held in a trust, a living trust, an inter vivos trust, a revocable trust, an irrevocable trust, you don't have to go through probate because it's already held where you want it held. It doesn't need to go anyplace. Quick review. I won't spend too much time on this, a lot of numbers, but you can at least reflect on it in terms of this is intestate, died without a will. This is the state's best effort to try to figure out some sensible way to cause a distribution of a decedent's property if he or she dies without a will. So down the left-hand column, you can see if that decedent who died without a will left a spouse and descendants, to the right it tells you what's going to happen. Okay? Then if you leave a spouse but no issue, no descendants, but you leave parents, it tells you what's going to happen. And then if you didn't leave a spouse, but you left, you survived, your husband or wife left children, it goes to the children equally at each generation, meaning children get equal shares and grandchildren would share what a deceased child would have gotten. All right? A couple of other things just in terms of lots of times people will say, well, who are my heirs? a sassy lawyer would say, you only have heirs if you die without a will. The word heir is a function of intestacy. It's basically the people who would take your property if you died without a will. So you can see that, or maybe you can't see, but I will tell you, Massachusetts has changed its laws over the years to reflect changes in society. It used to be, not so many years ago, that an adopted child did not take as an heir of the adoptive parent unless the parent actually said that they wanted to have the adopted child take. Or if you had the classic, grandma set up a trust, it goes to children and deceased, and issue of deceased children, adopteds would not have been in. You had to affirmatively put them in. The law has changed now and said basically adopteds are treated the same as natural children born to the adopting parent. A lot of blended families now. The law has changed to include so-called kindred of the half-blood. It's a great, sounds like some kind of, I don't know what, wrestler or something, kindred of the half-blood. Half-sibs. Stepchildren do not inherit. So if somebody is married, the spouse has children from another marriage, so that person is not, well, in my example, suppose I married a woman who had children from a previous marriage, and I did not adopt those children, but was their stepfather, they would not be my heirs, okay? Children born out of wedlock, as you would logically expect, since adopteds used to not be in, illegitimate children were definitely not in. They're in now. Okay? And it used to be in most states they would inherit, if they inherited, they would inherit through the mother, because it was pretty easy to prove. But they would not inherit through the father. They now inherit through the mother and the father. Other things on people's rights. I'll get to the details of this in a minute. Important stuff, again, just to get your mental arms around estate planning. Spouses do have rights. You can't eliminate your spouse. I mean, suppose my wife and I were separated, not getting along. I could make a will that said I leave her nothing, but she could elect against the will and take what is often called a forced share. And I'll get to what the spouse would have the right to take in a minute. Other relatives, including your kids, have no right to inherit. If you were unhappily in a situation where you said, I've got 4 children and one of them I haven't seen in 25 years, and I don't want to provide for that child, you can simply say, my failure to make any provision in this estate plan for my daughter Susan is intentional and not occasioned by accident or mistake. I will admonish you, advise you, warn you, entreat you. If you do have that kind of a situation, keep it simple. Don't say why. And it's not just not to rub it in. You don't want to create a situation, and this is one of those cardinal rules of estate planning, which I learned actually from the late Emil Slazewski at the Boston College Law School. Precatory language, classic. Because my son Michael is well provided for, comma. I say, I'm not well provided for. She might have thought I was well provided. If my mother had known that I had this business problem and went through a bankruptcy, when she wrote it, I was in good shape. So you wind up having an avoidable fight. If you say, because my son Michael never visited me, I'm making no provision for what's his name, If you're going to leave somebody out, just leave them out, and you can keep your reasons to yourself, okay? If you do have this situation where you are married, I've had situations, I remember, it's why it's important to ask the right questions, like being a doctor, you have to ask a lot of questions of your clients because sometimes they give you unexpected answers. I was dealing with a client that I was confident was either a widow or had never, I knew she had married, but I assumed that she was divorced or widowed. Because she'd never talked about her husband, and there was no husband in the picture, and the children talked about having not seen their father. They thought he was still living. Well, it turned out they were separated, and they had been separated for 40 of the 42 years of their marriage. So they lived happily together for 2 years, or unhappily together for 2 years, and then they separated. I said, oh my gosh, your husband can actually elect against your estate plan because he's really your husband. So this is what they would get. If there's a spouse and there's issue, they get $25,000 outright and a life estate and a third of the remaining property. If there's spouse and no issue, but kindred, like other people, your parents, siblings, then you can see what they get. So they don't get a great deal, but they do get something. There is currently legislation pending in the Great and General Court, otherwise known as the Massachusetts Legislature, that would change those rules and basically give the electing spouse a much better deal, I'll call it. I won't get into the details because it's really beyond the scope of my remarks this morning, but there is regularly presented to the Massachusetts court on behalf of kind of what I mean this in a jocular way, like the disgruntled spouses lobby saying, we should get a better deal. You shouldn't be able to give us only X. So that usually doesn't make much progress, but it's out there again. Effective marriage, sometimes people say, well, I don't need to do this estate planning because I have a will. Sometimes people who think they have a will really don't because they've gotten married, it's changed their will, it's revoked their will. If you have a will when you're a single person, or suppose you were married, somebody gets divorced, they do a will during that time, then they get remarried, you can see here, it revokes the provisions for all persons other than descendants, unless the will is stated to be in contemplation of marriage. So that's the kind of a bunch of background. The effect of divorce on a will you can also read. If somebody has a will, they get divorced, you say, oh, does that revoke, does that invalidate my will? I had a will, but then I got divorced. You can see what it does. Again, logically, it does what you would expect. It keeps the will in place effectively, but revokes any bequest to a spouse or relatives of a former spouse. It also revokes any nomination of the former spouse as a fiduciary. And then, of course, because the law loves symmetry, it says under bullet 3, if one were to remarry one's former spouse, then you get a do-over on the will. So what's your will do? Your will disposes of the things you own in your own name, which we now all know to be called probate property. So for most average Joes and Janes, what's their probate property consist of? Their probate property consists of tangibles, your car, you've got a boat, things in your house, the jewelry, the necklace around your neck, your wedding ring, things like that. Real estate that you own in your own name. Again, if it's joint, it's not probate. Bank accounts, mutual funds, investments. Remember, all things that you own in your own name alone. That's what passes under a will. Your will does not govern joint property. Your will does not cover life insurance. Your will does not cover retirement accounts. The biggest mistake we see, and again, one of these, I always think when you do something like this, people should come out with maybe 3 or 4 things that were worth spending an hour listening for those 3 or 4 things. Among the 3 or 4 things that one can learn is that wills simply govern what you own in your own name. They don't govern joint property, life insurance, or retirement accounts. So lots of times what you'll see is somebody goes and they do their will, but they don't coordinate the passage of the rest of their stuff. Most of their estate consists of their pension plans, their IRA, their KEO, their 401k, their life insurance. That all has to be coordinated. That's really what the estate planning process encompasses. The will, for those of you who have minor children or a disabled child, that's where you name guardians. It's also, of course, where you name somebody to execute the will, now called in Massachusetts a personal representative. 9 times out of 10, when we're doing estate planning, and it doesn't need to be for a very wealthy person, we will do a very simple form of will, called in kind of lawyer jargon a pour-over will. Why pour-over? Because property pours over from the person's will to their pre-existing revocable trust. Sometimes called revocable trust. You might say, oh, gee, I have a living trust. Yes, that's the same thing. An inter vivos trust, that's the same thing. So a living trust or a revocable trust is, from my perspective as a planner, essentially a will substitute. The kind of stuff that in the old days you used to put into a will, you can put into a living trust. What is it? The bullets make it pretty clear. It's a written trust document. You can change it anytime you want. Sometimes people say, oh, I don't want to do a trust. Trusts are complicated, trusts are expensive, trusts are bad. My uncle had a trust and the trustee was a mean bank and we could never get any money from them. That's not this kind of trust, at least not yet. A living trust is essentially yours. It can be funded during your lifetime. As I said, a lot of times what we're dealing with at our firm are people who have lost their fastball, they're 93, they don't balance their checkbook well anymore, they miss deadlines. Having a funded revocable trust where that person's assets are housed and they've got some trusted trustee, whether it's a professional or a family member, or two people, maybe a professional and a family member, that kind of vehicle, a funded living trust, is enormously valuable as the person ages and if they become incapacitated. Maybe not legally, but certainly that mom's just not repeating herself. She's not opening the mail. We have stale checks we're finding around. Having a funded revocable trust allows somebody else to basically run your money for you, have access to it, so you have to really trust the person. But it also makes the administration of an estate extremely smooth. So, and the stuff that's in it avoids probate. Why? Because it's already in the trust. Now, remember, somebody says, oh, does that have any effect on taxes? None, zero. If it's done properly, it doesn't require filing an income tax return for the trust while you're living. The expected tax result is it's yours. You could do anything you want with it. You could end it, revoke it, give it all away, spend it all, do whatever you want. Therefore, it's in your taxable estate. So whether you have a Massachusetts tax or a federal tax, it's in your estate. Irrevocable trusts, and I'll talk about how they can be used in a bit. Irrevocable trusts are irrevocable. They cannot be amended. Once it's done, it's done. You've got to be very careful when you put property into an irrevocable trust. It usually has some tax advantage. That's why people do it, because when you make a gift, if you make a lifetime gift and you put something into an irrevocable trust and you don't retain certain rights over it, the property will have been given away. So suppose I was a reasonably wealthy person and I wanted to set up a trust for my grandchildren, and I just wanted to give them money. I wanted to set up a trust to pay for their education, we'll say. I would likely be advised to set up an irrevocable trust, push money into that, get it out of my estate, and then the trust would be a taxpayer. The trust itself would have the income, the interest, the dividends, and I would have gotten money out of my estate. Sometimes we'll see for an entrepreneur, somebody who's starting a business or thinks they're going to cash out at some point, they may take property when it's less valuable, move it into an irrevocable trust, deal with the gift tax implications, knowing that, like sliding the ship into the bottle and then pulling the sails up, if you had some stock, some investment, or you work for a company that you have options or something, sometimes people will say, well, gee, I think this is going to be really valuable. And I'd like to give some of it away now so that when it becomes valuable, it's not in my estate. You would likely use an irrevocable trust for that. The advantages of a trust, for everybody, and I'm trying to focus on things of general truth as opposed to, that really doesn't relate to me, I don't have $10 million. The fact is, trusts are usable and useful on many levels. You have little kids. I have 3 grandchildren. If I wanted to give something to my grandchildren who are, 10, 7, and 3, I probably would be wise to have it held up until some later date, or they'll buy hockey sticks with it or something. So it allows you to, basically what does a trust do? It's like I got this remote here, I'm getting to use it right now, but I don't own it, right? It's owned by Boston College. It says it right on it. So somebody else owns this thing that I'm getting to use beneficially right now. That's effectively what a trust is, all right? The trust is a remote. No. A trust is a vehicle. It allows you to put legal title to something in a trustee for the benefit of someone else. That's what a trust is. That simple. Trust didn't exist until English land law kind of said, gee, we really need to figure out a way to allow people to put title to something in X for the benefit of Y, or into the name of X for the benefit of X, Y, and Z, so that they don't all have to own it. It's not unlike a corporation, like why did corporations come to be? So that you can have an entity that owns something for the benefit of the stockholders. Trusts are like that. Certain kinds of trusts can save estate generation skipping taxes. A trust obviously is useful if you say, well, gee, I've always managed the money, my husband is not really very competent with money, but I would want to take care of that person for his or her survivorship period, but I want somebody else to manage the money. Or that person is not the father of my children, and I want to benefit that person, but I want to make sure the money goes to my kids. Special needs children, grandchildren, bunch of different things that are pretty straightforward. Planning for incapacity. So I'm talking here about the way property that you own in your own name, you want to have a will. Property that you want perhaps managed, property that you want to set aside for a spouse, property that you want to set aside for your children or for charity, you're probably going to use a companion, living, or revocable trust. But ignore the distinction between them. They are really intended in modern estate planning to be working hand in glove, will and trust. For me as a drafter, it doesn't really make a lot of difference. But if you have an ongoing trust, suppose you set up a trust for your spouse and for your children that splits into shares after the death of your spouse, when your youngest child reaches age 25, and then continues for the children for tax reasons for their lives. It's a real pain to run a trust like that under a will, because you have to go to the probate court year after year and prove your accounts. It's just a pain. It's expensive, it's time-consuming, and as long as you trust the trustee, it's also it's unnecessary from a substantive point of view. It doesn't provide you with any great protection for the pain that it will put your family through and the trustees through for years to come. Using a non-probate trust that was revocable while you were living and became irrevocable upon your death is a much better way to do it. Now, when you go, you'll leave here and you'll be filled with this zeal for estate planning, and you'll think, I'm going to go do estate planning. So I'm going shopping for the basic tools of estate planning. What does the well-dressed estate planning man or woman have in their estate planning wardrobe? They're going to have a will. They're probably going to have a companion revocable trust unless they have an extremely simple situation. And again, if you have an extremely simple situation, you say, look, I've got a couple of $100,000 and a house. I got one child. I want to leave my daughter, everything. You could have a simple will that said, upon my death, my tangibles, my real estate, anything else I have in the world goes to my daughter if she survives me. If not, to her issue who survived me in equal shares by right of representation, and you'd be pretty much finished. The other stuff that pretty much everybody needs consists of a durable power of attorney and a healthcare proxy. Durable power of attorney, most people are reasonably familiar with a power of attorney, or at least they think they are. So, oh yeah, he has power of attorney. He can basically act as if he were the other person. So the simplest example is, I'm going to go on a 6-month around-the-world trip. And, I may be reachable at times, I may not be reachable at times. But gee, while I'm away, maybe my tax returns will have to be filed. Or maybe something will happen with some investment of mine and somebody will have to sign my name. So I'm going to give power of attorney to my son. Durable. Why durable? Durable powers of attorney came into the law about 25 years ago or so. And they came in, and this is, to me, a useful thing to know, because you may have a power of attorney that's not a durable power of attorney. It used to be, and follow what I'm about to say, imagine I gave, Paul, I see him, suppose I gave Paul a power of attorney. And then, so he's managing my affairs for me. And then I become incompetent. I have a stroke. Now I really need a power of attorney, right? Under the classic law, my incapacity, this horrible stroke that I suffered, revoked the power of attorney. Huh? Why? Well, the notion was, well, maybe I would have revoked it. Because remember, powers of attorney are always revocable by the so-called principal, the person who sets it up. So the law didn't want to take any chances. The law said, well, maybe Puzo doesn't want this guy to be his attorney in fact anymore. Maybe he was okay when he could kind of keep an eye on him, but now he's had a stroke. So it voided the power of attorney. And then you'd have to go to court and get a conservator appointed or a guardian appointed. And you really didn't want it. All you wanted was to have your son or daughter who held this power of attorney able to manage your affairs in case you couldn't. Enter the durable power of attorney. The law in this area, and another good thing to realize and reflect upon, as I was saying, adopteds, illegitimate children, second marriages, blended families. The law in this area tends to react, I was going to say after the fact, which I guess is redundant, to react to changes in human behavior. So you started seeing a situation where people said, darn it, I really want that power of attorney to stay in effect. That's why I set the blasted thing up. So now, for the last 25 years, you can establish a durable power of attorney where you basically provide specifically that you intend that this power of attorney should withstand or remain in effect even in the event of your incapacity. Now, there's another form, and again, as you go out of this room and you think you start to make some choices or sit with a lawyer, you can do a durable power of attorney in one of two ways. As the great jurist Yogi Berra said, when you come to a fork in the road, take it. The fork in the road on a durable power of attorney is you can have a power of attorney that is in effect from day one and stays in effect even in the event of your incapacity, okay? Or you can have, which has facial appeal to people, or you can have a power of attorney which only becomes effective if you become incapacitated, a so-called springing power of attorney, okay? Now, the problem with the latter, and the reason I regularly advise against it, is the triggering event without which the power of attorney is ineffective, my incapacity. How do I prove that? You imagine you go into a bank. Oh, I have a power of attorney here from my dad, Mr. Puzo. Well, it says it's only effective he's incapacitated. Oh, he is. Going to need a medical opinion. Going to need a court proceeding. He has to be proven to be incapacitated. Well, I have a letter here from his doctor. I'll tell you, 9 out of 10 banks, mutual fund companies, Merrill Lynch, whoever it is, they're going to say, sorry. Can't accept that. I don't know the doctor. I don't know if the doctor is board certified to make this decision. So I would suggest stick with a durable power of attorney. Very practical point. Less frequently than infrequently, but not rarely. We'll say to a client who's a little squeamish about giving somebody a power of attorney that's effective day one, number one, you picked the wrong person if you're that worried about it. Well, he's the best I've got. Say, we'll hold the power of attorney. Don't tell him it exists. And if you start getting dotty or we think you really need it, we'll spring it on him, but it's not going to be a formal springing power of attorney. Healthcare proxies. So again, the big four in estate planning are having a sensible will that disposes of your property the way you want it to go, names a person to administer your estate, so-called personal representative, makes provision if you have minor children or a disabled child or somebody you're responsible for naming guardians. Then you've got this trust, the so-called revocable trust, inter vivos trust, living trust, that takes care of the distribution of most of your property. You've got a durable power of attorney, hopefully the one that's effective from day one, so that you're sure it's effective when it comes time to use it. And then you've got a healthcare proxy. Massachusetts has a healthcare proxy law. Most people are familiar with it, particularly since the HIPAA changes came in, because nobody will let you into a hospital without signing a healthcare proxy. If you don't have one in effect, they'll give you a form as part of your admission to the BI or something. They'll say, do you have a healthcare proxy, ma'am? No, I don't. Here, fine, fill this out. It's basically a specialized power of attorney. That's what it is. It designates an agent to make healthcare decisions for you if you're unable to make them yourself. Okay? Now, of the 4 instruments, this is the one, I mean, a durable power of attorney is too, but this is one where you're actually giving a person, could be life and death, power over you. We think this drug might help this person, but it's not been approved for this use. You know, somebody has a certain type of cancer, there's a drug that they think, well, this could be useful, but it's not been approved for that type of cancer. Will you allow mom, dad, husband, wife to get it? She's currently incapacitated. You have to make the call. So the healthcare proxy law is, and the healthcare proxy rather, is an important document, and it's a very sensitive document. It's the document in which you obviously make decisions about feeding tubes, I mean, fun stuff, right? Feeding tubes, do not resuscitate, no codes, these kinds of things. There are, for many of our clients, they have visceral reactions to healthcare proxies. They have religious reactions. At what point do I give up life-sustaining treatments? There's a very good position paper for people who might be interested in reading one from the United States Conference of Catholic Bishops on, you know, kind of Catholic issues in designating healthcare proxies and making end-of-life decisions. It's not black or white, and it's intensely personal. Among the things that people tend to put in healthcare proxies, I mean, you could have mindful that a healthcare proxy is just what I said it is. It's a specialized power of attorney. Massachusetts does not have a living will statute, okay? Some states do, we don't. We followed years ago the Karen Ann Quinlan case. Later we followed the Terry Schiavo case, right? And everybody was, oh, poor Terry Schiavo. Does she live? Does she die? Do we take the feeding tubes, life-sustaining treatment? She's in a persistent vegetative state, a so-called PVS. The real issue in that case was nobody knew what Terry wanted. The parents disagreed with the former spouse, and there was a big brouhaha, which obviously captivated the public attention and the media for a very long time. If Terry Schiavo had left a healthcare proxy that had a section in it that really wasn't necessary because it doesn't have anything to do with the agency, the healthcare proxies are also the place where you can tell the world what you want in the event of my incapacity. If I should be in a persistent vegetative state, which is a term with meaning, you know, it's not just turn me toward the sun. I mean, the notion is I have lost brain function, I am basically in this persistent vegetative state. Then people say, well, then what would I want? Would I want feeding withheld, nutrition withheld, hydration withheld? Then we have doctors review these things for us, and when we were futzing away years ago when this law first came in, someone said, well, you can't do that. I mean, I can't give pain meds to somebody who's in a coma other than through hydration. So you can't say, I don't want hydration. If you say I don't want hydration, that means you're going to die of dehydration in agony, you know? So you're like, oh, that doesn't sound good. So these are, you know, suffice it to say that these kinds of decisions are big ones. The one further caveat I would give you is don't let these kinds of decisions get in the way of having a reasonably sound estate plan. It is way too frequent that, you know, putting off to tomorrow. This is an area where people procrastinate. They procrastinate for a number of reasons. They think they're going to die if they do an estate plan, right? It's like, oh, you know, if I go to the dentist, they'll find that I need a drill. So it's bizarre sometimes. People put off estate planning because it forces them to face their mortality, and they don't want to. Or they think it's going to hasten their death. It doesn't do that, at least. That's when you get the bill. The big things that slow people down, we don't know who to name as guardians for our children. My husband and I don't agree. I think it should be my sister and her husband. He thinks it should be his brother and his wife. So we don't agree. I say, you know what, then just do your will, do your trust, do your durable power of attorney, do your healthcare proxy, and let them sort it out. You're probably not going to die, both of you, with minor children. And if, God forbid, that should happen, somebody, the children aren't going to be wandering the streets. Something will happen. So there's that old saw, Voltaire, the perfect is the enemy of the good. So, as you search for the perfect solution, you're probably going to miss good ones. So take a good one. And if you're not sure what to do, God forbid, if I should be in a persistent vegetative state, just pass on it. Say, I name my wife to be my healthcare proxy holder, to make healthcare decisions on my behalf, in such manner as she thinks is in my best interest and consistent with my wishes. And if that's the best you can do, that's the best you can do. Living wills, again, would provide directions for healthcare agents and also burial or cremation instructions. Another thing that people don't do, estate planning technically is not the place you would say, I want to be cremated and have my remains deposited at the Holyhood Cemetery in Brookline. But a piece of advice is don't leave it to your kids, or particularly where there's a second marriage. It is an unnecessary, again, it's like unforced errors in tennis or fumbles in football. I mean, avoid the avoidable. It's one of my mantras of being a lawyer. We try to help you avoid the avoidable. And one of the fights is, where should somebody be buried? I just can't burn mom's body. I can't do it. Well, she wanted to be cremated. So avoid passing the buck on these difficult decisions. Taxes. I said I wouldn't start with taxes because I think that taxes are not that relevant to many of us, but they are still relevant. So a quick course on taxes. The Massachusetts estate tax and the federal estate tax are wealth transfer taxes, all right? I'm not trying to turn you into tax lawyers, but I think if you understand the concepts, it really helps. So we don't have an inheritance tax. Inheritance taxes really focus on who the recipient is in relationship to the donor. We don't have that, so forget I ever said it. What we have is an estate tax. An estate tax is a wealth transfer tax. So obviously, one of the first things you have to do when you're trying to apply an estate tax is figure out what is the sum total of this person's wealth. So just imagine you're going out gathering up, So you say, okay, they own this, they own that, they had money in a irrevocable trust, they had a house on the Cape, it was in joint names, so at least half of it should be in the estate. So what you do, if I'm handling, suppose I was handling somebody's estate, preparing their estate tax return, it starts with what is the person's gross estate? What do they have? You total it all up. Take out a piece of paper, or nowadays a computer, and you add, you input all the data. You get all of the stuff. Then there are some things that are deductions. It's not unlike an income tax return. Everybody's familiar with that. You got your gross income, then you get some adjustments to gross income that gets you to adjusted taxable income. Then you get some deductions, real estate taxes, charitable contributions, state taxes against your federal income. You get those deductions on Schedule A, and it gets you down to taxable income. Same kind of concept here, except what you're doing is aggregating wealth, not income. Then you're taking off deductions. And what are the common deductions? Common deductions that people have, and the same holds true for Mass as federal. Administrative expenses. Suppose you had somebody with a $2 million estate all in. They may be paying a lawyer or an accountant to do the cleanup, to do the estate tax return, to handle the probate, do those things. Those are administrative expenses. They are considered to be ordinary and necessary in the administration of the estate. They come off the gross estate. So gross estate's the whole enchilada. Then you start figuring out your deductions. suppose you leave money to your husband or wife, and let's keep it simple, suppose you left it to him outright. There is the marital deduction, okay? Very often, the marital deduction is not done as an outright gift, but a gift in trust, and it's very often done by virtue of a formula, and not like a physics formula. It's a tax formula that says, I leave basically to this trust from my husband or wife whatever amount is necessary to reduce my estate taxes to zero. So if it's Bill Gates, that's a big number. Bill Gates can only leave $5.34 million to Melinda. So everything north of $5.34 million, you're either going to pay a tax on federally, and if you do have some big whopping estate or you die, you find out you won megabucks and you're so excited you keel over, and you say, oh my God, person had a $360 million estate. The federal estate tax is now 40%. It's down, all right? When I started practice, it was 70. Then it went to 55. Now it's 40. It's a flat 40%. But if somebody has a big estate, well, they have $20 million subject to tax, it's going to be $8 million that you send to the feds. Massachusetts has an independent estate tax that tops out at 16%. So these are big taxes. The primary deductions people have, expenses, again, remember what you're doing, you're looking at net taxable. Suppose I have a house in Hingham that's worth $800,000, but there's a $300,000 mortgage. The way an estate tax return works, you put $800,000 onto the real estate schedule, and you put the debt onto the debt schedule, so that the net value is all that's includable. The other big deduction that many taxpayers have, including people who are favorably disposed toward Boston College or members of the Shaw Society, they have a deduction for charitable gifts. So if you left 50 grand to BC, or you left, in my hypo earlier, a quarter of your TIAA CREF balance to the Boston College, you would get a charitable deduction for that in computing your estate tax. We put up here just a quick tabular of a pretty normal kind of estate. Person, have a couple of cars, some things, jewelry, they have a house, probably bought it for who knows what, owned it for a long time, becomes valuable. They have some accounts, bank accounts, brokerage account, vacation home, bunch of life insurance, IRAs, 401ks, added up, so whoa, it's $2 million. Didn't feel like I was a millionaire. I said, well, sure you didn't, because you basically was tied up in things that weren't producing income. But at death, they became valuable. Or at death, you had to total everything up. This estate obviously would be under the threshold for Fed, but it would be a taxable estate from Massachusetts. Presumably what this couple would do is they would take care of each other and try to get the amount that was subject to the Mass estate tax down. A couple of other tax issues, gift taxes. Most people don't ever worry about gift taxes because they never make taxable gifts. But just in terms of takeaways, Massachusetts does not have a gift tax. So if you are in a situation where you are making gifts that are over and above the amount that you can give annually, which is $14,000 per person in 2013 and is remaining at that level in 2014, you do have to be aware of the fact that Massachusetts has no gift tax, and remain aware of the federal gift tax. Sometimes the second to the last bullet is relevant for many of our clients who aren't super rich, and certainly is for those who are super rich. There is, in addition to the annual exclusion, which is the $14,000 per person freebie, there is an exclusion for medical and tuition payments made directly to the provider. So we'll have clients who have excess resources, say it's a grandparent who's paying for somebody's tuition. They're giving that grandchild $14,000, or if they're married, maybe the grandpa and the grandmother are both giving $14,000 to that grandchild who, say, is here at BC. They can pay the person's tuition without it being treated as a gift. room and board, different, and the money has to go directly to the provider. So if you are in a situation where you're paying somebody's tuition, or very often we're seeing now an adult child is paying medical expenses for a parent. There's, before this second to the last rule came in, and I talked about how the law kind of reacts here. What happened in this section of the code used to be that you could pay somebody's tuition without it going afoul of the $14,000 per person annual exclusion. But then tuitions went up and up and up. It shows on my name tag I'm parent. Right. So I had 4 children go to Boston College. If I had been limited by the $14,000 annual exclusion, I couldn't have paid their tuition without technically creating a gift, because I'm not obliged under the law to send my children to Boston College. So there is a special provision that allows gift giving north of $14,000 without it giving rise to with a gift tax federally. Remember, Mass has none, so long as it's for qualified medical expenses and tuition, and so long as it's paid directly to the provider. Federal estate tax, if this is relevant to you, congratulations. It means you have at least $5.34 million as a decedent, and for a married couple until they're north of $10.68 million, they really don't have to worry about this. The marital deduction is unlimited. Remember, the way I try to remember it, or at least before I memorized it, after 36 years you get it down, was deductions. The marital deduction is a deferral mechanism. Lots of words start with D, bad words like death, deferral, right, dearth. So all the marital deduction does is defer the tax to the second death. So in my Gates example, for instance, if Bill Gates left $500 million in trust for Melinda, Bill's estate would pay no tax so long as Melinda was surviving him. But the full measure of the $500 million, or if it had grown to $1 billion at Melinda's death, would be subject to tax in her estate at 40%, if that was the then rate. Now, if Melinda had been wise and remarried, she could re-gift the money to spouse 2, and you could, if you had some sort of sequential marriage, I suppose you'd never have to pay the tax. But it would probably probably just better off paying the tax. But whether it's for Mass, now Mass here, because this is more relevant to most folks, the Mass estate tax starts at 5.6%, it goes up to 16%, and you only get $1 million exclusion. $1 million, as I said, sounds like a lot of money, but when you start thinking about life insurance, couple of houses, retirement benefits, lots of people are millionaires as estates, even if they weren't millionaires as living people. So a married couple obviously would have 2 $1 million exclusions. Once that couple is north of an aggregate of $2 million, they're going to have a Mass estate tax to worry about. And in my hypo that I showed you with the Mr. and Mrs. Smith that had the $2 million, suppose Mr. Smith had said, well, I don't want all this complicated stuff. I love my wife, I trust my wife, we've been together for 50 years, I'm leaving everything to her. So Mr. Smith dies, and whatever his estate is, suppose it was half of the $2 million, he leaves his $1 million, to keep it simple, to her, right? So now Mrs. Smith has what? $2 million. The limbo stick for federal is way up high. But for Mass, there's a separate limbo stick, and it is set at $1 million. Mrs. Smith has had her beloved husband leave her his $1 million. Now she's got $2 million. Hits the limbo stick. She's going to pay an estate tax on that $2 million of about 100 grand. Okay? Suppose what Mr. Smith had done was said, I love you very much, but I'm going to use one of those formulas that I heard about at the lecture. And it's going to say, I leave my beloved wife that amount as is necessary to pay no Mass estate tax or federal estate tax in my estate. The federal is irrelevant in my hypothetical because it's so it's because it's irrelevant, that's why. But for math purposes, if Mr. Smith has $1 million, he doesn't need to leave his wife a dime to pay no mass estate tax. Because he's got you can think of these things like gift certificates, like coupons, you know? Would you like to pay for your dinner in cash, or would you like to use your gift certificate? Oh, I think I'll use my gift certificate, right? You say, would you like to pay this tax, or would you like not to pay the tax? You know, I would like not to pay the tax. Okay. Then plan your estate so that you don't invite a tax that you could easily avoid. So in the way you would do this, the way most people do it, you got your will, you have your trust. The trust has a formula provision in that says, set aside for my spouse whatever amount is necessary to eliminate estate taxes at my death. In my hypothetical, that's zero. Now, Mrs. Smith could get very grumpy, because Mrs. Smith would say, oh, great, so I get zero? I needed that $1 million for my life. No, we're putting it into a trust, which is a sub-trust inside the living trust. We'll call it the marital trust. Clever name. The marital trust is designed to take advantage of the marital deduction if it's needed. And so what you would do is you would fund the trust for Mrs. Smith so that she had access to the money, but she didn't own it. Back to my remote, right? So there'd be a trust that benefited her, but wasn't hers for tax purposes. And it would take way too long to explain how you do that. But suffice it to say that it's very easy, and you set up a trust that requires a tax election. Think of it as a switch. If you want the deduction, actually think about it more like a dimmer, okay? Not a flick switch. Think about it as a dimmer. You would turn, how much deduction do I need? Do I need a big deduction, like all of it? Then you'd turn it all the way to full brightness. Or do I only need a little? Or do I need none? In my hypothetical, you would need none. So you would not elect marital deduction treatment, which means what? Which means it's subject to tax, because you want it to be subject to tax. It's like, come get me, you know, because when they come to get you, and they really don't, it's pretty nice process actually, but you set it at exactly the amount you know you can exempt. So if you're Gates or you're Mike Puzo, we both get the same limits, all right? The limits for me are high enough that I don't have to worry about federal estate taxes, but I do have to worry about mass estate taxes. But I don't want to leave my wife high and dry. So what I do is you split the estates. The other kind of takeaway to put in bold on your sheets is, you know, avoid joint property. Even if you're happily married, beyond your house or maybe your vacation home, if you're fortunate enough to have one, joint property is really dumb. All right? Joint property doesn't know what to do. You know, joint property is like, Mike's dead, I go to Chris. Chris is dead, I go to Mike. So, oh no, they have this really cool estate plan. And it's got little buckets, and it's got formulas, and it's got sub-trusts. Joint property does one thing. On spouse one, when spouse one dies, it goes to spouse two. And now when spouse two dies, obviously, unless there's spouse three, then joint property is what? No longer joint property because the prior joint owner has died. But joint property mucks up a lot of estate plans because you've got all these pretty formula, and you can think about, I often will with clients will say, these things are like, you know, like you pour, like in chemistry class or something, you pour something into a beaker, and then it flows down into different places. That's what these estate plans do. The money gets poured in on top, and then it goes certain places depending upon the formula. Joint property is like over here. You know? It's like, what are you doing over there? I wanted you over here. That's why it's critical that you coordinate your plans. So in sum, will, trust, durable power of attorney, healthcare proxy. That's where you do your tax planning. That's where you do your illness planning. That's where you think about who would I want to handle my affairs if I was losing it? Who do I trust enough to handle my money? don't think that the same person who handles your money is necessarily going to be the holder of a healthcare proxy. So no, that's different. My child could not make that decision. They would think they were, throwing mama off the train, There are kids who just say, I couldn't do that. I could not make that decision. Another important thing, and not even old lawyers get this, not that we're some higher sort of being, we're just supposed to know this. You can only have one healthcare proxy holder at a time. Oh, I want the girls, the twins. Can't. Only one at a time. The healthcare world does not want to deal with two people, particularly if they don't agree, okay? So you can say it's X if no XY. You can say it's X, but I request that X consult with Y, but you can't name two people. So the estate planning process should allow you to provide properly for your estate when you die, to make sure you use tax deductions to the extent you need them. Very few people need them for federal, but most of us do need them for mass. If you are north, suppose you say, well, I'm a survivor, and I've got $1.5 million, all this various property, and I really would like to avoid the mass estate tax if I can. Then what you would have to do is you'd have to begin making some gifts, particularly as you get toward the back nine, or you think I'm putting on 18, it's time to give things away. That's when you'd have to start moving money out. Because remember, Mass doesn't have a gift tax. So a lot of people can eliminate or substantially reduce the Massachusetts estate tax bite by giving away property. The downside of giving away property is it's gone, And if you try to say, well, can I put it into a trust and still get it? Well, you can, but it won't be a taxable gift, and it will be in your estate. And I've seen, we're pretty straightforward about the kind of advice we give. Our firm was started actually the same year as Boston College, so we've been in this business for a long time. We're like, look, every gimmick you can think of has been tried and failed. The way this system works legitimately is you hold property, have dominion over it, have control over it, it's yours. It's like tag, you're it. You have the money, it's yours. If you want to give it away, give it away. Don't try to give it away and keep it, okay? There are ways you can have some kind of potential beneficial interest through a spouse, but as far as I'm concerned, those things just haven't failed yet. They're new, cutting edge. And said, you know what, the problem with the cutting edge is you can get cut. And we try to avoid that stuff. The other thing that I would be delinquent, particularly talking to people who have TIA, CREF, many of you, I'm sure, if somebody is planning a charitable gift, and it doesn't need to be, Stokes Hall. I mean, if somebody is making a charitable gift, and you have retirement benefits, they are the perfect tool, vehicle to use as your charitable planning device. Why? Most retirement benefits, the classic, money in a 401k, money in TIA CREF, that is taxable income on which you have not yet been taxed, right? I mean, most of those things are, if I put money into a 401k at work or have my pension plan at work, that's money that I didn't get as taxable income. Now, I know that if I left it to my kids, forget my wife for a minute, if I left it to my kids, they would have to pay income tax on it. But suppose my IRA is $600,000, and I leave a quarter of it to Boston College, so they get $150,000. They don't have to pay any tax. They're tax exempt. So it's a very efficient way to make a charitable gift because it's tax-free. I get an estate tax deduction for the $150,000 in my example, and BC gets the $150,000 with no tax. If I try to leave it to my kids, it would be taxable for estate tax purposes, and it would be income to them for income tax purposes. So if you assume that I'm in a 40% estate tax bracket, and they're in a 30% or so income tax bracket, very quickly you can see 70% or so of a dollar going out to income and estate taxes, whereas if it went to a charity, whether it's BC or St. Elizabeth's or something, well, it wouldn't be St. Elizabeth's anymore, would it? Since they're now a for-profit hospital, Mass General, it would be tax exempt. So those basic concepts. I've taken an hour or so of your time. Hopefully it's been at least marginally useful. And I'd be happy to answer questions that are of general interest. And if you have specific questions that you don't want to share with the group, I'll hang around as long as you need me to. And Christine's walking around the mic. She's like Vanna White. That's right. That's right.
Good morning, and thank you for this
You bet.
terrific presentation. If you have money in both, let's say, TIA, CREF, or anything similar to it, are you better off leaving a percentage or designating beneficiary percentage within your structure with TIA, CREF, or should you have all of that money transferred or, flow to your trust and have it done that way?
Door number one. Okay, so you would, it's a wonderful question on a few levels, because it also reinforces the important distinction between probate property and non-probate property. You've got an account at TIA CREF, they do a great job, they manage money. There's an account in your name, right? And you fill out a beneficiary designation form. So you have a contract with them. And the minute Leo Sullivan's office says, oh, this person has passed away, TIA CREF looks, they say, oh, this is supposed to go in 5 equal shares to A, B, C, D, E. And so that's the way you would do it. There are ways sometimes to have that money come out, but suffice it to say that estate planning for retirement benefits is the most complicated field of assets, no question about it. I mean, there are people, there's one Boston lawyer, Natalie Choate, who's made an entire career of lecturing and teaching people like me about how to plan properly for the distribution of retirement benefits, particularly if it's some big corporate muckety-muck that has tons of money. It's really complicated at high levels. But for most of us, you do it through, if it's Fidelity or TIAA CREF or whoever it is, you just do it through them, and you just make sure you do it. And make sure that your estate plan is not silent, if that's the right word. You want to make sure that it's taken into account. So what you wouldn't want to do, for example, would be to have an estate plan where some kids are getting X and some kids are getting TIAA CREF, and then you think they're kind of in balance. Suppose you have your TIAA CREF and you have private money, and you say, well, I'm going to leave the private money to X and I'm going to leave the TIAA CREF here. And you think those things are kind of current, and perhaps you're right when you do it, that they're currently in balance. If they get out of balance, you can have a real problem, all right? So there was a question over here. Yes, ma'am.
Can you explain, I think a lot of people here own joint property and the prices go up quickly here. Can you explain again why the joint property triggers the estate tax, and is it just unavoidable if you're married and you own property with someone else? Or did I misunderstand you completely?
No. So if somebody's married and they bought a house, say they bought a house for $300,000, now it's worth $1.5 million. It's like, oh my God, Chris and I bought a house in Hingham, it was like $250,000. It's probably worth $900,000 now. It's joint. If I were to be the first one to die, my half of the house would go to my surviving spouse, and there'd be no tax because she's my wife. Now, it would be on top of whatever else she might own. So what you're really worried about in most situations is not death one, even for the Gateses, it's death two. So what you're trying to do is to make sure. Now, the reason I say joint property is dumb is, suppose, I'll make up some horrible thing. Christine and I are driving home from the BC North Carolina State game last Saturday, and we're in a terrible automobile accident. I'm killed. A month later, she succumbs to her injuries. All of my property, if I have some dumb, we call them in the trade, I love you will, if everything goes to her, my life insurance, I have a lot of life insurance, my life insurance, my 401k, blah, 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 she's got this huge estate. She has a multi-million-dollar estate. All be taxed. That's why it's critical to avoid, let me state it positively, what you want is separate estates. You want to have, because you have separate credits. In one sense, it's pretty simple. You want to use your credit, all right? So the husband has a credit, the wife has a credit. The feds finally, after years of effectively lobbying, have made the credits transferable. I mean, we used to ask, at these seminars and Federal Tax Institute, why don't you make it transferable? I mean, you can give pollution credits. Like companies sell the right to pollute the earth, right, to some other company who is polluting. Say, can I get some of your pollution credits? I'd like to go pollute. But you couldn't leave your spouse your tax credits. And it was also, lawyers to a fault can be logical. It was also illogical. You say, if I can leave all of my property to my wife because you treat us as one economic unit, then how come she can't have my credit? Can't I just leave her everything I have, including my gift certificate? So now you can do that. But the problem that you implicitly have raised is if a couple has a lot of joint property, and that same couple has life insurance payable to each other, and IRAs and KIOs and 401ks and TIA crests payable to each other, effectively what they're doing is they're shifting lots of assets to estate 2. If estates 1 and 2, I'm meeting with clients later today, they have very modest estate. They're not going to have to pay an estate tax, federal or state. They can lump everything into one estate, and it will still be south of $1 million. So they really don't have to worry. But because of real estate values around here, and 401ks and TIA crefts, a lot of people have more than $1 million. A lot of people have more than $2 million. And so avoiding or eliminating or at least deferring the mass estate tax is the big tax issue for most people in the Commonwealth who aren't wicked rich, as they would say. Yes, ma'am.
I'm one of 4 children.
Congratulations.
It might be old technology, but my mother, my father predeceased my mother, and my mother went and got some kind of a living trust, I think, and she put all 4 children on her house. That was the big concern, is that it passed without probate back in the day to us equally. And there were like 4 deeds or something, and she just had the fear of God that one of us would kick her out of her house. I'm sure other people have had that said to them as well.
Not an unreasonable fear.
Because we owned the house, but she still wanted to live there until, of course, her death.
Yeah.
Is that a recommended way to go about this now, as I now have 4 children? What should we be doing?
What do you
Or is
think
that
my,
old
what do you think my
technology?
answer is going to be? No.
No. It's old technology, right?
Yes, right. Old, flawed technology. Yeah, I'm happy to talk to you separately. That kind of planning, number one, if you transfer, remember I said you can't kind of transfer it and keep it? If somebody had come and said, oh, can you handle this estate? Mom has transferred ownership of the house to a trust that is nominally owned by her 4 children, but she has effectively retained the right to live there for the rest of her life. It's hers for tax purposes. It's still hers. It has not gotten out of her estate. Now, I'll tell you that unwittingly, I think the most avoided tax, and I will call it evaded, there's that famous thing, it's okay to avoid taxes, you can't evade them. The most unintentionally evaded tax is the estate tax. Kind of a combination of the estate tax and the gift tax. Suppose I gave my kid $100,000, she's getting married, and I have a lot of money, I'm going to give you $100,000, not just for the wedding, I'm going to give you $100,000 so you and Harry can start your lives. That's a taxable gift. A lot of people, they don't even know it, they just do it. They don't do it to be sneaky. They just don't realize the tax exists. So they don't pay it. And unlike a W-2 or something where you get paid and they report it to the government, they withhold, there's a system. There's no system that polices this. So it's a much easier tax to unwittingly avoid. Then you get people, probably like your mom, who says, no, I gave it away. I don't own it anymore. Oh, yes, you do. You don't own it legally, but you own it beneficially. And that's how this tax is determined. It's based upon reality, not, it's based on substance and not form. I'll get you in a second. Yes, Miss in the back.
So you mentioned briefly the revocable trust that becomes irrevocable.
Yep.
Yes, so does that get around the problem if one would like to bequeath real estate and investments free of the estate tax, but one would like to retain discretion?
Your smile shows that you know the answer to your question. Right. Your mother told you can't have your cake and eat it too, and all those kinds of, no, you can't. I mean, now again, remember that unless you're talking big bucks, there is no estate tax to avoid, all right? And if you want to avoid the tax, the only way to avoid it is to start making gifts where you have no retained interest. And you put, most people don't have enough excess resources to do that. They say, I can't afford to give that away. That's my retirement fund, or that's my, yes, miss, sorry, go ahead.
Just out of curiosity, what would be the reason then for doing a revocable trust that becomes irrevocable like that?
My sassy answer would be, well, you died, so you really can't revoke it anymore. It kind of, your death made it irrevocable. Because while you're living, my less sassy answer is, while you're living, you want the right to change it. I mean, suppose you say in your living trust, I have these gifts I want to make, $50,000 to this one, $25,000 to that one, this amount to Boston College, this amount to my spouse, this amount to my son-in-law, Frank, Oh, Frank's not my son-in-law anymore. I want to change that. My child got divorced. I got divorced. I can't believe what Boston College is doing nowadays. I don't want to leave them any more money. So you'd want the right to change it. You want the right to change it. Easy, John. You want the right to change it. But then you say, but when I die, now it's done. Now it's thy will be done. Now, because remember, it's a will substitute. You're dead. Now you want it frozen. Now you say, this is it. The music has stopped. Now this is what I want to have happen. And I don't want people changing it after the fact. That's why you do it. Yes, sir.
To follow up on this woman's question, could her mother pay rent
Could she?
and have that be the solution to that?
There are ways to do a trust where you, yes, how's that for a short answer? Most people don't want to pay fair market rent, but you could, you could enter into a fair market rental, and you would be among the few people who did so.
But my other, just made me think creatively. When do I want to move to North Carolina? How rich do I want to be before avoiding the Massachusetts estate tax pays for my house in a non-estate tax state? These are real questions for a lot of people across the Northeast.
Oh, yes, no, I'm reasonably well aware of that.
Yeah, I know you know.
There are a few ways to answer the question. Massachusetts obviously has an income tax. So long as you're living here or living here part of the year, you got to pay an income tax. I was sitting last week in Osterville with a client who was very wealthy, and that person is a Massachusetts domiciliary, as we say, and he's very he watches his many pennies very carefully, and he was talking about how he didn't understand why we were telling him, but you spend so much time in Florida, you really have to think about changing your domicile. Oh, no, he has an accountant, and the accountant said that it really doesn't cost him that much.
And he said, now, one of the reasons I like this person is that she charges me $1,500 a year to do my return. And I know you guys would charge a lot more than that. And I said, well, that's true. But the beauty of the advice you're getting right now is you're paying like $1,500 a year, and then you'll pay about $4 million for this bad advice when you die. So you basically, it's like a deferred fee. I said, we would charge you like $3,500 a year, and you'd avoid the $4 million. So to this question, if you're going to move, number one, like this, do you really have to move? You know, oh, I'm a Florida resident. You know, how much time do you spend there? How big is your house in Florida versus how big is your house in Massachusetts? Are you still a resident member of Oakley? Oh, yeah, I am. You still get envelopes from St. Ignatius? Oh, yeah, I do. You know, you're not a Florida resident. But you can look and say, okay, would I avoid? Suppose you're retired and you have $80,000 a year of income from various sources. He said, would I avoid the roughly 5% mass tax? Yes. Does Florida have an income tax? No. Florida does have an intangibles tax, but it doesn't have an income tax. And then it has no estate tax. So if you've got a $2 million estate and you die a Florida domiciliary, you're going to avoid $100,000 in tax. Now, if you still have a house in Massachusetts, that will be subject to the Massachusetts estate tax. It doesn't, unless you live in a trailer or something, you bring it to Florida. So for people, the short answer is you can run the numbers and you can see what's it going to cost to remain a Massachusetts resident and die as one, effectively. We have conversations with clients who, some people say, hey, I'm out of here. I lived here, it was great, raised kids here. We have clients who say, I lived here, raised the kids here, I don't want to leave, effectively at the last minute to go to some other state to avoid this tax. Remember that if somebody's married, the tax is going to be deferred until spouse two's death. And even if somebody dies unmarried, at least you don't have to pay the tax. Like you don't have to write the check yourself. So it's really a question, and we tell clients all the time, look, you're doing this for your kids. I mean, you're not doing this for yourself or your spouse. The question is, the impact on you. If somebody says, like me here, I mean, I grew up in northern New Jersey, as you probably have detected at some point from some word I butchered. I've lived here now since I started BC in 1970. I don't want to move, And it isn't as though I feel, I really feel as if I owe, I'd like to pay $250,000 to the Massachusetts Department of Revenue, because I think they do such good things, But I've taken advantage of a lot of things that the Commonwealth offers, I mean, I drove out here, used the roads, you do all the things that public taxes pay for. And I pay my income taxes every year. You can have, as you know, the estate tax is an unpopular tax for a number of reasons. It's like, why? Why do I have to pay this tax? And now the feds have kind of recognized that. They say, unless you're because the logic for the estate tax has always been a public policy issue. It's been, kind of Jacksonian democracy and breaking up wealth and all that kind of stuff. You say it doesn't do that. It doesn't do it. And usually wealth and power, where they are really abusive, are in the hands of the first people who made it, not the fifth generation. They're usually just, that's just offensive to people, so they want to take it. So the somewhat long-winded answer is, you can quantify the cost for taxes. But there's a lot more than that, It's like, I've got married kids, grandchildren. Do I want to be in North Carolina when they're raising their families in Hingham? No. Oh, congratulations. Oh, no. Well, that's a good reason to move to North Carolina, not to avoid taxes. Any other questions? Yes, sir, in the back, and then we'll...
Thank you.
And if people feel like enough already, I got to go, you won't offend me if you leave.
Thank you for making what can be a dry subject humorous almost and interesting.
You got to do something for 36 years. You can't.
I'm curious about the estate example you use with Jack and Jane Smith. The biggest piece of it, of their Massachusetts estate at least, aside from the real estate, is insurance. Is there some way I've heard that there are
Yes.
ways of excluding insurance from the estate, and how can you do that? I guess that's the question.
Yep. That's a good question, and also that I should have addressed it without having had a question. Life insurance. The question, of course, is posed on this, Jack and Jane hypo, and 600,000. So 30% of this aggregate estate is life insurance. Yes, life insurance planning can be pretty advantageous, particularly if it's term life insurance, or whether it's whole or term. You can establish what's called an irrevocable life insurance trust, sometimes in the jargon called an ILIT, I-L-I-T. Irrevocable life insurance trust is basically a one-trick pony, but it does a great trick. So it's a good question. Next time I do this talk, I'll make sure I raise it without being invited to do so. So here you've got life insurance, and it's really not worth much unless you die. So you say, well, gee, and then it's worth a lot, and I have to pay an estate tax on it. Why don't I give it away? Why don't I'll give it away. So you say, well, who are you going to give it to? Sometimes, like in the old days, when people kept stuff simpler than they do now, you just gave it to your wife or your kids. So but what happens? It's important. Life insurance. Usually there are like three major players in a life insurance contract. There's the insured, the life that is insured. There's the owner, and there's the beneficiary. So in the classic life insurance, like here, suppose this is, to keep it simple, suppose it's $600,000 worth of life insurance on Jack's life, and he owns it. So in the classic, he owns the life insurance, it's on his life, and on his death, it's payable to Jane, if no Jane, the kids. What he could do, if he was willing to put up with some annual housekeeping, and I'll explain what's involved in a second, is he could transfer ownership of the life insurance policy to the Jack Smith Irrevocable Life Insurance Trust. So now he doesn't own it anymore, Jane doesn't own it, a trust owns it. And the trust would be not only the owner, it would be designated as the beneficiary. So when Jack kicks the bucket, the $600,000 is collected within a week or so of the availability of his death certificate. It's collected by the trustees of the trust. And so long as he owned no beneficial interest in the trust, so long as he didn't retain any forbidden power, and I'll suffice it to say, it's easily, those mines are well marked. You can walk that thicket without doing any damage to yourself. The life insurance will be out of the estate. Now, there are a few very specific rules. If one is, suppose you're going to go buy life insurance, like me, it's in my instance where I went and bought a lot of life insurance at one point. You are best not, let me state it again positively, the best way to do it is to buy it in the life insurance trust. So I never own it. I don't want to own it because there are rules about transfers of life insurance. Now, suppose I say, oh, well, too late, I already own it. I've got $1 million policy, and I heard this good question that was posed at BC, and I think I'd like to transfer the life insurance to get it out of my estate because it's really not worth anything to me while I'm alive. And I just want a death benefit for my spouse or my kids. So can I do this? So there, if you own the policy, you would talk to the agent. You would first set up an irrevocable life insurance trust. You would then do an irrevocable instrument of transfer. All the companies have them. They do this every day. And you would give it away. If it had value, suppose it was a whole life insurance policy and it had investment value, it's built up value, you have to get the value from the insurance company, and and you'd have to take it into account for gift tax purposes. If it was a big policy and had a big value, you would be making a taxable gift. But life insurance is usually worth a heck of a lot more when the guy dies, or the girl dies, than the investment value, right? Even if it's a whole life policy. There are a couple of wrinkles. I said I'd talk about just some of the nits. Lots of clients do this. Very often, thoughtful life insurance agents will say, hey, you know, you should do this in an ILIT. You should do this in an irrevocable life insurance trust. But this requires ongoing maintenance, I'll call it, okay? Because suppose premiums are due. So now you give the thing to the life insurance, and all it owns is the policy. So now I've got the Michael Puzo Irrevocable Life Insurance Trust, or the Jack Smith Life Insurance Trust, and it owns one thing. It owns a $600,000 life insurance policy. It has no money. Now the premium bill comes in. You know, it's $4,000. Got to keep the premium paid, otherwise the life insurance will lapse. Jack can't pay the premium, or he'll be making a gift. What Jack needs to do, and I'll bore even myself, is Jack needs to give money to the trust each year, and he needs to fill out some paperwork each year, and the trustees need to fill out some paperwork each year. You're much better off, if you're going to do this, and this is not make work for lawyers or accountants, at least in the first couple of years, let them do the notices. Let them do the annual maintenance. Because if you don't do it, no one notices for years. I mean, these come up in estates, probably 1 out of 5 estates. And the IRS knows that people screw this up. They don't do it right. And what happens is, without going into all the gory details, they find that they've made a series of taxable gifts over many years without realizing it. So the bright line answer is, just as retirement benefits are great vehicles for charitable giving, life insurance is a great vehicle for irrevocable trust planning while you're living, because you're not giving up much. You know, if you take your securities account and stick them into an irrevocable trust, going back to that young lady's question in the back, you know, you're giving up interest, dividends, access to capital. Life insurance usually isn't worth a heck of a lot until you die. So it's a great vehicle to give away into a trust that allows it to be out of your estate and also allows you to take advantage of the annual gift tax exclusion for the ongoing premium payments, so long as you're making them, and I'll just give you the phrase because you may hear it and think, I wonder if that's what he was talking about. These things are referred to in the jargon as crummy trusts. All right? Now, that's not a pejorative, value judgment on the trust. It's not crummy. The person who first thought of this was the lawyer for a man whose surname was Crummy, Crummey. And this lawyer came up with this way of kind of doing this. So they call them crummy trusts. So if some lawyer says, oh, yeah, you're talking about a crummy life insurance trust. You say, no, I want a good life insurance trust. But that's what they are.
And then the trust distributes the money to the beneficiary?
Yeah, the trust could pay it out, or the trust could retain it, make it available to the spouse and kids for many years to come, and have it go tax-free to the grandchildren. There was a question back there someplace. Yes, sir. Yep. Yep. You could pay my children's tuition. You could pay anyone's tuition. Doesn't have to be a grandchild, doesn't have to be a child, doesn't have to be a relative. If you saw oh my gosh, I read about this person whose parents were killed, I'm going to pay his tuition. You can pay his tuition. It is unlimited. The same thing on the $14,000. You could give, if somebody was wealthy and they could give, and I've seen, clients that they give $14,000 to this one, $14,000 to that one. They have somebody they like. They have somebody who works for them. They have somebody who was down on his luck. They make a whole bunch of annual exclusions. And the reason for this is the IRS doesn't want to get involved. I mean, if there was not the annual exclusion, you'd be worried about, oh, gee, I bought Dad a shirt for Father's Day. Is that a taxable gift? I wasn't obliged to buy him a shirt. I bought my daughter a car. Is that a gift? you know? So they try to set a threshold below which they don't want to hear from you. It used to be $3,000. Many of us remember, oh, it was the $3,000 annual exclusion. And if I gift split with my spouse, it's $6,000. Now it's $14,000. And as I said earlier, you know, the $10,000 annual exclusion, which is what it was a few years ago, was inadequate to allow you to pay tuition. Suppose you had to pay, you know, my mother's passed away now, but I was paying her nursing home costs at one point. It was $12,000 a month, you know. The only way to avoid making a taxable gift was to pay Harbor House directly, and therefore it was not a gift. And these are kind of forced gifts. I mean, if you think about the underlying tax logic, they're considered to be practically forced gifts. You've got to make these payments, and they don't want you to have to pay a gift tax. Any other questions? Class dismissed? All right. As I said, I'm happy to entertain any questions people didn't feel comfortable asking in the public forum. I thank you for your attention and the opportunity to speak with you.